Hello and welcome to another episode of Supreme Court Judgments of the Week on Verdictum. In this segment, we bring to you the most interesting judgments passed by the Supreme Court during the previous week. Let's begin. Dr. Nirmal Singh Panesar versus Mrs. Paramjeet Kaur Panesar, alias Arjinder Kaur Panesar. The present case, being a divorce petition, was placed for consideration before a bench of the Supreme Court comprising Justice Aniruddha Bose and Justice Bela M. Trivedi. The case revolves around the divorce petition filed by Nirmal Panesar on the grounds of cruelty by her wife Paramjeet Kaur Panesar. The petition was first filed in 1996, with the husband claiming that her wife refused to permanently relocate with him to Chennai, where he was stationed by the Indian Air Force in 1984. A district court granted divorce to the couple in 2000 on grounds of cruelty and desertion. But the order of the district court was challenged by the wife by way of an appeal and therefore was reversed. The couple has 3 children together, and the wife, who herself is aged 82 years, has expressed that she wanted to take care of her husband, who is presently 89 years old. Mrs. Panesar also expressed strong aversion to the word divorcee. Taking into account the emotional state of the wife, the Punjab and Haryana High Court overturned the divorce decree, which was passed by the district court. The matter then reached the Supreme Court in civil appeal, citing irretrievable breakdown of marriage as the ground for divorce. The top court dealt with the question whether it is mandatory to use powers under Article 142 of the Constitution of India to dissolve a marriage when it has irretrievably broken down, even if such a breakdown is not a ground for divorce under the Hindu Marriage Act of 1955. The top court opined that the power under Article 142 was a discretionary power, which could be exercised for dissolution of marriage on the ground of irretrievable breakdown to do complete justice to both the parties. However, in the present case, one of the spouse opposes the prayer for dissolution of marriage. The court observed that despite the increasing trend of filing for divorce, the institution of marriage is still considered pious, spiritual, and invaluable to emotional life between the husband and wife in the Indian society. And it would not be desirable to adopt a straitjacket formula for granting divorce by using Article 142 on the ground of irretrievable breakdown of marriage. The court concluded that given the emotional state of the wife, who although living separately, has devoted her whole life for the well-being of the 3 children, and who has expressed that she did not want to die with the stigma of being a divorcee woman, granting a divorce will not do complete justice to both parties. The court therefore refused to grant divorce to the couple. Divya versus Union of India and others. A 2-judge bench of Justice J.K. Maheshwari and Justice K.V. Vishwanathan of the Supreme Court dismissed 3 writ petitions filed by the UPSC candidates for claiming the economically weaker section reservation. The 3 petitions were filed against the Union Public Service Commission for treating the candidates as belonging to general category, for not submitting the EWS quota certificates in the prescribed format and before the cutoff date of the Civil Services examination for the year 2022. The petitioners claimed that though they were eligible candidates under the EWS category, the non-submission of certificates was only a delay caused in the production of proof. The main question for consideration before the Supreme Court was whether the UPSC was justified in denying the benefit of the reservation to the candidates under the EWS category. The top court ruled in favor of UPSC and said that we cannot fault the method adopted by the UPSC, as the Commission was justified in rejecting the claim of candidates for being treated under the EWS quota, as the candidates failed to furnish the requisite certificates before the cutoff date. The court further held that the candidates not in possession of valid documentation determining their eligibility in the prescribed format and before the prescribed cutoff date cannot complain if their claim for categorization as EWS was rejected. Naresh versus State of Haryana. A 2-judge bench of the Supreme Court comprising Justice S. Ravindra Bhatt and Justice Arvind Kumar acquitted 3 persons convicted under Section 302 of the IPC that deals with the punishment of murder, and Section 149 that provides that every member of an unlawful assembly shall be guilty of offence committed in pursuance of common object. The accused persons were convicted by the trial court by relying on the testimony of the eyewitness. The FIR was also registered on the basis of the statement made by the eyewitness. The gist of the case is that in April 2016, a police officer received a telephonic tip that a young boy had gun fired in a nearby village. The assistant sub-inspector Ramkishan arrived at the scene of occurrence, where the main eyewitness in the case named Mohit was present, who told the police officer that two of his cousins, namely Ajay and Suraj, were chased by three persons on a bullet motorbike, while two other bikes followed. The eyewitness said that an unknown person shot at Ajay, after which he was rushed to the hospital and succumbed to injuries a day later. Based on the statements, the FIR was lodged, the accused were taken into custody, and charges were framed. There were 6 accused in the case who were convicted by the Sessions Court, and the conviction was later also upheld by the High Court in appeal in 2020. The decision of the High Court was challenged before the Supreme Court. The Apex Court found many discrepancies and inconsistencies in the statements of the eyewitness Mohit. The court held that this is the third stage of the deficient investigation, and blame has to be necessarily laid at their door, and the benefit of the doubt has to be extended to the accused persons. The court further held that the prosecution had failed to prove the guilt of the accused beyond reasonable doubt, and non-consideration of the lacuna in the prosecution case in proper perspective by the trial court and the High Court has resulted in miscarriage in the administration of justice. In conclusion, the court said that the evidence of the eyewitness should be of sterling quality and caliber, and should not only instill confidence in the court to accept the same, but it should be a version of such nature that can be accepted at its face value. With that, I am Ananya saying thank you for watching Verdictum. For more such informative content, don't forget to subscribe to our channel and download the Verdictum app on iOS and Android for latest legal news.